Welcome to War Story Wednesdays. Today I want to talk about a case that frankly just burns my bacon because it puts form over substance. A buyer made an offer to buy property for $41,600 with a close of escrow in 30 days, all cash, no contingencies. The seller made a counteroffer, filled out the form that said counteroffer, and said, no, not $41,600, instead $44,000. Now, the original offer was dated November 2nd, and the counteroffer was dated November 6th. And the buyer checked the wrong box and didn't just say, I accept the counteroffer, but instead marked the box that said counter offer and put in there that the close of escrow would be December 6th. Now, the counteroffer says close of escrow 30 days from acceptance. The counteroffer was dated November 6th. 30 days is December 6th. So what did the buyer add by adding the date December 6th to the counter offer? Not a single thing. He agreed to the $44,000 price. So what was the material change? In fact, what was any change in the counter offer? Not a single thing. There was a trial because the buyer sued for specific performance and lost. There was an appeal because the buyer didn't like that decision, and frankly, neither do I. And the buyer lost again. The Court of Appeals logic was this. The form says counter. The buyer could have just marked the box that said, I accept the counteroffer. And rather than try to guess what the buyer might have meant by $44,000 and December 6th, the court strictly construed what the form said, that it was a counter to the counter. And as long as there isn't an absolute and unconditional acceptance of a counteroffer, it's deemed not to have yet formed a contract. And this seller changed his mind and canceled the deal in between the time that he wrote counteroffer and received counter to counteroffer. The buyer got screwed out of this deal, and I don't think that the buyer did anything wrong. What's the takeaway from you as an agent or a brokerage for a case like this? Normally, I will tell you that the form is your friend and that you should use the forms and not try to create something on your own. That you should be incredibly careful when you write counteroffers because the law of unintended consequences means you'll get punished for whatever the good deed is you're trying to do. If you've got in-house counsel for the brokerage, or if there's a lawyer for the buyer or the seller, you should direct your client to the lawyers. And no, this is not the full employment for lawyer speech. This case is a really good lesson in how trying to do the right thing and checking the wrong box can have disastrous consequences. You need to study the forms. You need to be careful about how you use them. Know them backward and forward. Be careful.